Different types of procedures at the Cjeu and the General Court. What is the purpose of this video?
The EU courts are at the center of the judicial system of the European Union. A consistent and complete set of procedures enables them to ensure that the law is observed in the interpretation and application of EU law. These procedures are essential to provide individuals, member states and the EU institutions with legal certainty on EU law, and also to ensure that they are all equal before the law. Those procedures can be divided in essence into groups. On one side, some procedures are specifically designed to guarantee the uniform application of EU law and also to ensure that individuals effectively enjoy the rights conferred upon them by EU law. Infringement proceedings against the member states, preliminary rulings on the interpretation of EU law, which represent the largest part of the court's workload, accounting for about 65% of all new cases in 2022. On the other side, some procedures are specifically designed to review the legality of the Union's action or inaction. In a Union based on the rule of law, EU acts must indeed comply with higher-ranking rules of Union law, including general principles. Those procedures are essentially the following: action for annulment, action for failure to act, preliminary ruling on validity, and action for damages. There is also an incidental plea in law, the objection of illegality, that can be raised in the context of an action for annulment lodged before the Union courts and challenging the validity of an EU act relevant to the proceedings. Lastly, two special forms of procedures are worth mentioning: appeals against decisions of the General Court and interim measures.
Chapter 1. Infringement Proceedings. What is the purpose of infringement proceedings?
The purpose of the infringement proceedings is to ensure that Member States fully comply with their EU obligations. The Court has exclusive competence for infringement proceedings. Those proceedings consist of two phases: a pre-litigation phase and a judicial phase. In the pre-litigation phase, the Member States concerned may clarify points of fact or of law. For example, that Member State may justify his behavior or his legislation. It also allows the Member States to comply with their obligations and thus avoid being sued before the court. Most infringement proceedings are initiated by the Commission, in accordance with its role as guardian of the treaties. The Member States also have the right to lodge an application against another Member State for an alleged infringement of EU obligation. An example a few years ago was the action lodged by Austria against Germany concerning the vignette for driving on highways in that latter Member State. The court held that the measure indirectly discriminated on grounds of nationality and restricted the free movement of goods and the freedom to provide services. By contrast, individual litigants may not initiate infringement proceedings directly. However, they can lodge a complaint to the Commission or even to the competent authorities of their home Member State. For example, an individual may complain about a Member State, arguing that air quality in his or her own city systematically and persistently fails to meet the requirements of the Ambient Air Quality Directive. Nevertheless, the Commission is not obliged to act on such a complaint.
Infringement proceedings must be initiated against the Member State as such, irrespective of whether the infringer is a constitutional body, a court, a territorial entity, or a private entity controlled by the state. If the Member State fails to reply to the letter of formal notice within the specified time limit, or provides the Commission with what the Commission regards as unsatisfactory replies, the Commission may then issue a reasoned opinion, crystallizing in fact and in law the alleged infringement. That reasoned opinion also prompts the Member State concerned to bring that infringement to an end within a specified period. The final time limit mentioned in that reasoned opinion is crucial. If infringement proceedings are brought before the court, the latter will assess the existence of an infringement of EU law at the expiry of the time limit. It means, for example, that if the Member State fulfills its obligations under EU law while the case is pending, the Commission is entitled to pursue the judicial proceedings if it so wishes.
Who bears the burden of proof?
In the judicial phase, the applicant, normally the Commission, bears the burden of proof as regards each head of claim. For example, if a national provision can be interpreted in two ways, the Commission will have to prove that the national courts interpret the domestic provision at issue inconsistently with Union law. But the Member State must always cooperate in good faith with the Commission.
What is the purpose of a judgment adopted in infringement proceedings?
A judgment finding an infringement is declaratory, because the court cannot declare national acts unlawful, void, or inapplicable. Such a judgment facilitates the task of lawyers when they seek to establish state liability for damage caused to their clients as a result of breaches of EU law. Thus, a judgment finding an infringement constitutes an authoritative recognition that the member state disregards EU law, and which all public authorities of that member state must therefore accept. If the member state fails to comply with that judgment, the Commission may request the imposition of financial penalties on that state in the form of a lump sum and/or a penalty payment. The first aiming at sanctioning the past infringement, and the second having to be paid as long as the infringement will persist. Those penalties aim to discourage future infringements of the same type by the member state concerned and also by the others. The amount takes into account the nature, the duration, and the gravity of the infringement, as well as the member state's ability to pay based on recent trends in his GDP. For example, the court emphasized that large-scale violations of EU secondary law dealing with water quality are particularly serious, as they are very harmful for human health and the environment. The Commission may also ask the court simultaneously to declare that the member state failed to notify measures transposing a legislative directive and to impose on that member state a lump sum or penalty payment. Here, there is thus no need for an initial infringement procedure to impose a financial penalty. The objective of those penalties being to give a stronger incentive to member states to transpose directives timely.
Chapter 2. Preliminary rulings on the interpretation of validity of EU law. Can you explain in general terms what the references for preliminary rulings stand for?
This procedure is the keystone of the EU judicial system. It ensures coherence and unity in the interpretation and application of EU law. It is one of the success stories of the whole process of European integration because it involves all judges across the European Union. This procedure allows for a direct dialogue between national courts and the Court of Justice on the interpretation or validity of EU law. Some of the paramount principles of EU law have been established through this mechanism. For example, the principles of direct effect and primacy. That dialogue is an essential tool for the court to clarify the scope and the effect of union law. It is therefore essential to ensure the correct interpretation and application of EU law in all the member states. In other words, the uniform application of EU law across the Union. The reference reflects the variety of issues of EU law which arise in disputes before national courts. For example, let us assume that a national court must determine whether an applicant is a consumer in the sense of the Brussels I recast regulation for the assessment of international jurisdiction. The applicant is a person who is earning a living from cryptocurrency transactions online trading platforms. He lodged the action before a court of the member state where he is domiciled. Brussels I regulation stipulates that consumers can bring proceedings in the EU member states in which they are domiciled, no matter where the defendant is domiciled. The national court refers the case to the Court of Justice if it has doubts on the criteria for interpreting the concept of consumer in order to assess whether a person who earns a living from cryptocurrency transactions fall into this concept. The preliminary ruling's interpretation will be binding not only on the referring court, but also on all other national courts, again, to ensure the uniform application of EU law across the Union.
Which bodies may refer?
Not any national body which applies EU law can refer a question on the interpretation and validity of EU law to the Cjeu, right?
Indeed, only a court or tribunal of a member state has that possibility, or sometimes obligation. The body has to be established by law, have a permanent character, be independent, and have compulsory jurisdiction. The procedure before that body must be inter partes, and its decisions are to be based on rules of law. The court recently clarified in 2022, in the Getting Noble Bank case, that judicial bodies must be presumed to fulfill those conditions, although that presumption can be rebutted in exceptional circumstances. For administrative bodies, that presumption does not apply. And I should add that the referring body must, of course, belong to a member state.
Yes, this is crucial. Only courts or tribunals of a member state can refer, and thus, in principle, international courts or arbitration bodies cannot. Moreover, a distinction is made by the treaty between last instance courts and other national courts, right?
Yes, there is an obligation to refer for last instance courts, which only knows limited exceptions. The failure of a last instance court can even give rise to an infringement action before the Court of Justice. For other national courts, the preliminary reference remains a possibility that can never be obstructed by political authorities or a Supreme or Constitutional Court.
Well, that's a conclusion we should always remember, no matter which member state we are from. That said, it is worth mentioning that for the Cjeu, national judicial hierarchies are not important.
It's true. The court's interpretation of EU law does not at all depend on the level of the national court that made the reference. Some preliminary rulings delivered in the past even made history, despite the fact they were delivered on grounds of a reference by a first instance court. Take, for example, the Frankovic case on civil liability of the member states for violations of EU law, or more recently the Popławski II case on the conditions under which national courts must set aside national rules violating EU law.
Are there any other conditions of admissibility?
National courts, including first instance courts, enjoy wide discretion to make a reference if they consider it necessary to decide a given case.
Yes, I think it is the national court which grasps the substance of the dispute and is therefore best placed to appraise the need for a preliminary ruling. There is thus a presumption of relevance of the question referred, which can, however, be rebutted in exceptional circumstances, of course. For example, if the issue raised bears no relation to the facts of the main action or to its purpose.
Article 94 of the Rules of Procedure specifies the information that must be made available to the Court of Justice with a reference.
Chapter 3. Direct Actions. Which court has jurisdiction over direct actions?
The Court of Justice and the General Court share jurisdiction in direct actions.
The General Court is the administrative court of the Union. It has a general jurisdiction to hear direct actions. The most important of these actions are actions for annulment. They can be brought before the General Court by natural or legal persons against acts of the institutions, bodies, offices or agencies of the European Union which are addressed to them or are of direct and individual concern to them. Typical examples of such cases are actions direct against Commission decisions in competition cases, EU public procurement decisions or against decisions taken by the European Central Bank. Natural and legal persons can also seek annulment of regulatory acts if and when these acts concern them directly and do not entail implementing measures. Other possible direct actions are actions seeking compensation for damage caused by the institutions or the bodies, offices or agencies of the European Union or their staff. Actions against the failure to act, Article 265 of the Functioning Treaty, on the part of those institutions, bodies, offices or agencies. Actions between the institutions and their staff. Actions based on contracts made by the European Union which explicitly give jurisdiction to the General Court. It should be noted that such actions can also be brought before the General Court by member states. For example, they may seek to contest Commission decisions in the field of state aid.
The Court of Justice has exclusive jurisdiction over actions of a more political, constitutional nature, such as an action of a member state or an institution against an EU legislative act. Thus, in two recent cases, the full court decided on two actions for annulment against the so-called rule of law conditionality regulation.
What are the peculiarities of an action for annulment before the CJEU?
The challenged act must be binding, which precludes the annulment of opinions and recommendations. It is reviewed in the light of higher-ranking rules of union law, including general principles such as legal certainty, rules of international law that are binding upon the Union, as well as fundamental rights. If a violation of such rules is found, the action will result in the annulment of the contested act. Judicial review exercised by the court is limited to the legality of the contested act, except when unlimited jurisdiction empowers the court to alter the contested act by taking into account all relevant circumstances. For example, modifying a fine imposed by the Commission in a competition case.
Chapter 4. Direct actions. What is an action for failure to act? Can you briefly present the action for failure to act?
The action for failure to act can be used where an institution, body or office has a legal obligation to act but fails to do so. Jurisdiction to hear actions for failure to act is shared between both union courts according to the same criteria as for actions for annulment. Private persons only have limited standing and must demonstrate an interest, typically that a decision had to be adopted and addressed to them in accordance with EU law. What is targeted here is a failure to take a decision or to define a position, and not the adoption of the measure that the applicant would like the institutions to adopt. The main difficulty for the applicant will usually be to prove a sufficiently clear and precise obligation to act that can also be enforced by a court.
Chapter 5. Direct actions. Action for damages. What is the purpose of the action for damages before EU courts?
An action for damages can be brought by a party seeking compensation for damage caused by the EU institutions, its bodies, offices or agencies, or by their servants in the performance of their duties. An action for damages must be filed within 5 years of the occurrence of the harmful event. Private litigants have to initiate those proceedings before the General Court. The applicant must prove several things. First, illegal conduct of the institutions or their servants. Second, the existence of a damage that is real and certain. Third, the existence of a causal link between the conduct and the damage claimed.
Chapter 6. Special procedures. The appeals. Can you present briefly the appeal procedure before the court?
The system of two-tier legal protection in front of the EU judicature increases the legitimacy of judicial decisions and the quality of legal protection. A recently added provision of the Statute of the Court establishes an admission mechanism for appeals in certain areas. The appeal shall not be examined on the merits unless the court decides that it should do so because it raises, and I quote, an issue that is significant with respect to the unity, consistency, or development of union law. Appeals on points of law may only be brought before the Court of Justice against judgments and orders of the General Court. A plea regarding factual findings made by the General Court is inadmissible, except where a distortion of the facts is invoked. The Court of Justice is also competent to review the legal qualification of the facts. Grounds of appeal may concern lack of competence of the General Court, a breach of procedure before it, which adversely affects the interests of the appellant, or more broadly, an infringement of union law by the General Court. Parties are not entitled to change the subject matter of the proceedings except for matters of public interest, which can also be raised ex officio by the court. An appeal must be lodged within 2 months, to which 10 days for distance are added. When in an appeal case, the Court of Justice annuls the judgment of the General Court, the Court of Justice may itself decide the case if it has all the necessary information before it. Otherwise, it refers the case back to the General Court after annulling the judgment under appeal.
Chapter 7. Special Procedures. Interim Measures. Can you present the interim proceedings?
The granting of interim measures may sometimes be necessary before judgment is given on the merits of a direct action. The interested party can lodge an application for interim measures, for example, a suspension of the challenged act in annulment proceedings or of the General Court judgment under appeal, since direct actions have no suspensory effect.
Other interim measures can also be adopted by EU courts, notably injunctions or a periodic penalty payment imposed on an institution or a member state. The President of the General Court has jurisdiction in interim proceedings for cases pending before that court.
The Vice President of the Court of Justice has jurisdiction in interim proceedings in 2 situations. First, where an appeal is lodged against a decision of the President of the General Court in interim proceedings. Second, where the interim proceedings are accessory to a case lodged before the Court of Justice, which can be annulment or infringement proceedings or an appeal against a judgment of the General Court. That said, if interim proceedings at the court raise a particularly difficult question, they can be reattributed to a chamber.
How do interim proceedings work in practice?
Interim proceedings are, by definition, incidental to a direct action. Interim measures must therefore be requested by a main party to the case and relate to that case.
Some procedural rules must be respected in the interim proceedings. For example, the application should be filed by a separate document. The judge has broad discretion on how to conduct the proceedings and to decide which measures or organization of procedure are appropriate. For example, the judge can request evidence from the parties or decide to hear them orally. Where necessary, an interim measure could even be granted ex parte without hearing the defendant.
Under which conditions are interim measures granted?
Both union courts apply the same cumulative conditions when they assess whether interim measures should be granted or not. Firstly, the main action must appear prima facie not to be unfounded. That's what we call fumus boni juris. Secondly, the interim measure must be such as to avoid serious and irreparable harm to the applicant's interest before judgment is given on the merits. The court is quite strict on that condition. Thirdly, the interest of the applicant in obtaining interim measures should outweigh the other interests at stake. For example, the environmental interest pursued by the challenged measure.
Conclusion.
The EU Judicature has established the distinctive constitutional characteristics of the EU legal order, protecting fundamental rights and upholding all other rights conferred upon citizens by EU law. In all procedures that have just been presented, the EU courts do not side with any of the parties, for example, the member states or the Union, but with the law, and with the law only. They ensure in this way that the Union is itself based on the rule of law. They cannot achieve that mission alone, however. The Court of Justice in particular needs the active cooperation of other actors, primarily the national courts, making references for a preliminary ruling and applying EU law in cases submitted to them. And lawyers' involvement is also crucial. They are on the front line to raise issues of EU law before national courts and can also bring cases directly before the EU courts when their clients can claim standing to challenge EU action or inaction.